Hello, my name is Christie Arkovich, and I'm a student loan attorney and bankruptcy attorney, founder of Arkovich Law here in Tampa, Florida. And I know that we've been placing a lot of emphasis on the federal restart for payments, and I wanted to just touch base real quick on what's going on with some of these private loans. Borrowers are going to be getting notification of a class action certification or following a class action certification in the Homadan case. If you wanted to Google that, it's HOMAIDAN. But basically, this was a national, this decision out of the Second Circuit addressed Navient's post-discharge collection efforts on private student loans, specifically those that were known as direct-to-consumer loans, a lot of tuition answer loans, things that were outside of the cost of attendance. And what that means is that every school has a specific cost of attendance, including room and board. And many of these loans were checks that were sent directly to the consumer borrowers. And they were intended, well, they covered things that were well beyond what that cost of attendance was. And basically, it's not just tuition, but it's also books and supplies, as well as room and board. And these checks were beyond all of that. And so are they really student loans? You know, they weren't taken and used for educational purposes. And this has been bantering about among different courts. We have filed actions here in Tampa arguing that these are not qualified education loans, and they therefore are discharged in a bankruptcy without, and this is the important part, without the necessity of actually filing an adversary proceeding. So what that means is that anyone who has previously filed a bankruptcy, this Homadan case is covering anyone who has gotten a discharge, the discharge's order is entered after October 17 of 2005. And so if you have filed a bankruptcy and you've gotten that discharge order after the October 17, 2005 deadline, then you may potentially be a class member if your loans fit that description, which means you're going to get notice. And the notice is probably going to go out in the next few weeks. And basically, you will have options. And one of the options is, do you want to opt in or opt out? And so I don't know the exact terms of this yet as to whether or not you'd want to opt in or opt out. We'll go ahead and probably do a subsequent video on that. I'm sure you can also find some things online. But usually with a class action, you want to opt out if you have specific damages, if you have a lot of damages that might be beyond what a typical class member would have. So what would that look like in this case? Well, let's say that you made a number of post-petition student loan payments. You've been paying off your loan after the bankruptcy. You've received a lot of collection efforts. Maybe there's been negative entries on your credit reports. Maybe there's been calls to you or third parties, or letters or other collection efforts, even lawsuits filed. If that sort of thing has happened in your situation, maybe you want to consider opting out, just because you have possibly specific damages that might be over and above what a class member has. On the other hand, if there's no student loan attorney in your area and you don't know thing one about how to go about doing this, then you might want to consider opting in, because this action has taken place without you having to engage. And that might be going to a deposition, might be providing documents, might be hiring an attorney. You haven't had to do any of that stuff. And so you might want to consider opting in. So we'll do a subsequent video in the future, but I'm sure that you're going to start getting notices. And I just wanted to let you know that another interesting thing about private student loans is that it is covered by the tax stimulus portion of the CARES Act, which basically means that, or it's one of the subsequent amendments to it, I forget the exact title, but essentially if you settle a private student loan debt before the end of 2025, the forgiveness is tax-free. That's normally not the law. Normally, if you settle a debt and you pay less than what's owed, you have to pay taxes on that, and you'll receive a 1099 for anything that's greater than $600. That is eliminated through the end of 2025. But it's important that you don't just do the settlement, agreement, or signing on the bottom line for the settlement agreement, but you actually complete the payments, which might mean you may have a amortizing payment throughout the couple of years here that's left on that, and maybe a final balloon payment in December of 2025. Maybe you have equal installment payments, whatever it is, you want to make sure the last payment is received by them. and basically cashed or negotiated before December 31 to make sure that you're covered by that act. So I hope this has been helpful for you. If you have time, I'd like for you to, and if you have additional questions, please consider subscribing to the YouTube videos here so we can continue to offer these. And also try to reach out to our office at 813-258-2808 or email us at info@ChristieArkovich.com. You also might scroll through some of the other videos we have. We try to name them specifically for the questions that might be asked. There's a lot of information out there now. Some of it's contradictory. Basically the Department of Ed has been doing things over the past year that has been the culmination of 20 years worth of effort before that. So a lot going on, but this is specifically for private loans. So have a great day. Thanks.